Preet Gill.
Speaker, and as we consider whether to put this bill into law, we must reflect on our solemn duty as legislators to protect the well-being of our communities and safeguard them from harm. And there has been much debate about giving people choice, what happens in other jurisdictions, and matters of faith and principle. And I've heard from nearly 8,000 constituents, the vast majority of whom oppose the bill for a range of reasons. I too oppose the bill at second reading, and I set out my concerns, including those of principle, but also of major concern about safeguarding. And as an ex-Children's Services manager with over 18 years frontline experience, far from issues of safeguarding being improved in committee, many of the provisions have actually been weakened. And my concerns are clear, actually very similar to the Right Honourable Member from Chingford and Woodford Green. The High Court stage safeguard was removed from the bill, fundamentally altering the basis on which members voted at second reading. And both the panels that replaced the court approval and the voluntary assisted dying commissioner who would oversee them are new and untested concepts. They would not have the powers or functions of a court or tribunal. They would not be required to question witnesses and could not compel them to attend. And the doctors who are intended to have assessed people's capacity and freedom to choose an assisted death would not give evidence on oath. And there would be nobody to cross-examine them. And the new Assisted Dying Commissioner would run the assisted dying system and at the same time be responsible for monitoring, investigating and reporting on its work, replacing the role previously given to the independent chief medical officers. And the very definition of terminal illness has proved to be seriously flawed, as it would allow people with anorexia to qualify once their physical condition deteriorates. And in committee stage, amendments were tabled to introduce an enhanced test of a person's mental capacity to make the choice to die. At second reading, members were assured that our existing laws in the Mental Capacity Act were tried and tested. Yet in February, the Chief Medical Officer wrote to the committee to clarify that there's no enhanced test for life and death decisions under this Act. The committee also voted to allow a future Health Secretary to change the Act of Parliament which established the founding principles of our NHS at will. This language first passed into law in 1946, established an NHS to secure the physical and mental health of the people of England and to prevent, diagnose and treat physical and mental illness. However, because this does not include assisting people to take their own lives, the bill as amended now contains a power for these foundational words to be changed by secondary legislation. Shameful. Following the committee stage, I chaired a session titled Committee of the Unheard to hear from experts who had not been invited to give oral evidence at committee stage. And we discussed the impact of excluding family and loved ones, which is this bill's position too. And importantly, this committee allowed us to explore issues around people with disabilities, people from other jurisdictions, specifically Canada, and BAME communities. And had the committee received the oral evidence, it may well have come to different conclusions. Finally, one thing the bill has highlighted for me is around the promise of choice. For choice to be real, there must be genuine options to choose from. But what has been highlighted is that palliative care provision is woefully inadequate. And the worst served are also the most disadvantaged from the most deprived communities. And worse, should the bill come into force, the provision of palliative care is likely to be compromised without hospices having a legal right to opt out of assisted dying. There is no such proposed opt-out in the bill. This brings me back to our role as legislators. The question for us now is, after all the consideration, can we be satisfied that our duties towards people to protect their well-being and safeguard them from harm are fulfilled if we pass this bill? From everything I've seen, heard and read, the answer must be no.